Hello landlords, it's Ernie Garcia, landlord attorney. Today we're talking all about that tenant who's left your property and left it a total mess. You've got thousands in repairs. What do you do? Talking all about that today. Let's get started. So it's bad enough that you struggle to get this tenant off your property in the first place. Now that you're back on the property and assessing what was left behind, you're finding a total and utter mess. What do you do when your tenant has left and just left a huge repair bill for you to have to deal with it? One that the security deposit alone is not going to cover. Well, I want to talk about a few things that you should consider whenever you are in a situation having to make some major repairs after your tenant has left. Now, the first thing that you should consider is whether or not the damage they caused was something that would be appropriate to file in an insurance claim. Now, you may have your own insurance policy that guards you from this kind of damage, but you're going to want to report it and let your insurance company know, because if you've got, say, a $5,000 deductible, that might help you in the event that your damages are $15,000 or $20,000 and they're covered. If that's the case for you, then insurance might be a really great option in terms of this kind of claim. Additionally, you may have a situation where the tenant has a liability policy, and this is something that I recommend to lots of landlords. One way to prevent some of these additional costs is to refer to the tenant's liability policy as a means for recovering whenever your tenant has damaged your property. If that's the case and you can file a claim and have their adjuster come out, it's possible that you are written a check to cover for those damages. But let's say that insurance was not part of your equation, and let's say that you're having to resolve these matters without the ability to make an insurance claim. Well, the next best thing for you to do would be to assess the difference between the damages caused by the tenant through their negligence or misuse and the damages caused by the tenants through ordinary use. Because there is a difference, and your ability to collect against your tenant is going to depend on this distinction. Generally speaking, the landlord cannot assess any costs against a tenant for damages to the property that are merely the result of ordinary use or normal wear and tear. This means that unless you can prove that they damaged the property from misuse or negligence, you're probably not going to be able to assess any of these costs against your tenant. It's just the normal things that happen when people live in a house. So some of these might be, for example, holes in the wall where pictures were, or scuffs and scrapes here and there that are not, again, out of the ordinary for a rental unit. These are the kinds of things that you probably cannot assess against your tenant. However, if there are outright intentional or negligent damages that were left on the property, for example, a broken window. Generally speaking, regular use doesn't result in broken windows, or maybe holes in the sheetrock that were caused through some kind of accident that resulted from the moving process or that happened during the tenancy. These kinds of things can be charged. Those repairs can be charged to your tenant and should be charged because they didn't result from normal use or normal wear and tear. By being able to determine which kind of damage you've got, you're going to know whether or not you can actually charge any of it to the tenant. So let's say you can determine that certain damages were the result of misuse or negligence. The next thing for you to determine is whether or not the thing that was damaged really had any value at all. That comes up when we're dealing with things that wear out over time. Carpet, for example, is one of those things. Carpet is not intended to last indefinitely. The fact that the carpet is totally ruined or totally worn out after a given tenancy does not necessarily mean that the replacement of that carpet is your tenant's responsibility. Remember, the facts matter in a case like this. So let's say that tenant A left, but and the carpet had to be completely replaced. But when they moved in, that carpet was already 7 years old. The fact that they moved in and occupied the unit after 7 years of the age of that carpet and stayed a full 12 months, and that the carpet had to be completely replaced after they left, might mean that the carpet reached the end of its life. And because it did, there's nothing that essentially can be charged to the tenant in this case. You are going to have to replace that carpet anyway, no matter who occupied it. The fact that there were, additional Kool-Aid stains or, uneven wear throughout the carpet may not amount to much when you're dealing with carpet that's already at the end of its life. The fact that they had 7-year-old carpet at the beginning does not mean that they're on the hook to replace with brand new carpet. Again, when things are at the end of their life, they tend to have zero to no value, and therefore replacement of them is not something that can be assessed against the tenant. Painting walls is another one of these things that comes up, and sometimes landlords are unsure how to determine whether or not a tenant can be assessed fees for painting. Well, here's some easy ones. If your lease absolutely prohibits the tenant from doing any kind of alteration to the property, including any painting, without your express permission, and you never gave permission to the tenant to do any kind of paint on the property, but they have, and now you're trying to restore the property back to status quo, then yes, at that point it is probably very likely that any claim you would have for damages due to their painting, you would be able to assess against that tenant. And they may argue, look, we had it professionally done. There's nothing improper about the paint that's on those walls, except for the violation of the painting in the first place. And if you're having to return the property back to its original condition because of a violation of the lease caused by the tenant, then yes, that is typically a valid basis for charging your tenant for that repair. Of course, your best resource is going to be your lease. Does your lease mention the responsibilities of the tenant throughout the tenancy, for example, to water the yard and to maintain the landscaping? If this is there, then it's up to you to make sure that you hold the tenant to this obligation. And it probably isn't enough that during the course of, say, a 3-year lease, you never visited the property once, so you had no idea that they simply weren't watering the yard, or that their dog ran all sorts of paths in the backyard, decimating the grass, or that the shrubs are just terribly unkempt and everything will have to be replaced or refurbished so that it is returned to its original condition. So your lease should make it very explicit what is and isn't allowed from the tenant, but you should also be the strongest proponent of your lease. And if it turns out that the tenant is in violation of the lease, you need to be on it from the beginning. Again, if you're going multiple years and not issuing lease violations, it's going to make it difficult for you to prove that the damages didn't result from what is otherwise normal wear and tear, or that you didn't just waive your claim. In fact, the section of your lease that describes how the security deposit funds are used is going to be extremely helpful to you, because it should explain that valid deductions from your security deposit can be made for violations of the lease. And it may even have a non-exhaustive list of the kinds of things that could result in deductions. By being able to point to the section in your lease that describes the charge that might come from, say, repair to the premises, or lawn maintenance, or any of the various other violations that the tenant could commit that would cause you economic harm. As long as you can point to a section in your lease, it's always helpful to be able to do that, so that when you are challenged, you can go directly there and let the tenant know that you have a basis for denial of their claim. So once you've made all of these considerations, you are then left to the courts. Now, the fact that you filed a lawsuit, or that you are responding to a lawsuit that was filed against you, is not the end of the world. Just because a lawsuit is in place doesn't necessarily mean that that case is going to trial. So our recommendation to our clients, whether they are seeking a lawsuit against someone else or are defending in a lawsuit from someone is to attempt at least once to try to reach some kind of settlement. Settlement is helpful because the parties involved have complete control of that outcome. Whereas with trial, you're putting everything into the hands of a judge, and depending on the presentation made that day and various other factors that could affect the outcome of a trial, there are too many variables for you to account as you lead up to that day. Whereas with settlement, this is something that could happen over the course of days or weeks even. It could take place at a mediation where the parties get together with a mediator who will assist both the plaintiff and the defendant to try to reach a settlement of all of the claims, or at least some of the claims in their case. This is helpful because it's a neutral third party who doesn't have the strength or the power of the court, but is just there to try to help both sides bridge the gap between them. And many times a mediation will have a positive result of both sides getting a little bit of what they wanted, so that the claim can be closed and then both sides can walk away feeling, if not content with the result, at least satisfied that the case is now over. However, if mediation fails or if all settlement attempts result in no agreement between you and the other party, you are last left to attend the trial and to present your case at trial. Now, in different jurisdictions, things are going to look differently procedurally. Rules of evidence and the rules of procedure are different from state to state and jurisdiction to jurisdiction. In fact, from judge to judge, some judges like things in a particular way that other judges within the same state or even the same county like them. And so those little things are important to look at. But, as a kind of broad base picture, how do you present your case so that you have success in a trial? I'm very big on having documentary evidence all the time. And that's where it's helpful if you have issued out written notices to your tenant in the past. Certainly if you've kept a set of photographs that can explain what the premises look like before the tenant took possession and what they look like immediately after the tenant had possession. That's always extremely helpful. If you have proof of the costs that you incurred to rehabilitate the property, that's always helpful. Having eyewitness testimony is somewhat helpful, but really you're the best eyewitness of the damages, generally speaking, because you went, you assessed the property, and so you don't need 5 or 6 people to testify to the exact same thing, having witnessed the damages that you already can testify to. The witnesses that you want to bring have to do with things that you otherwise don't have expertise on, or maybe to testify to the work that was performed to rehabilitate the property. Sometimes you have one of your contractors out there really just to explain the extent of the damage, particularly if, for example, the tenant did some repairs or did some modifications without permission, and they had to come in and fix the problems that were caused by the tenant, especially if the tenant makes the argument that your property was improved by the work that they did. Maybe you have someone in there who testifies, well, the reason this was not an improvement was because of X, Y, and Z, and they can testify as to why either A, the work was done poorly, or B, why it had to be undone and then reestablished in the way that it was originally presented to those tenants. So I hope you found today's video helpful and you take into consideration all the various factors that come into play after a tenant leaves property. Understand that a big part of proving your damages is up to you. It's up to you to keep good records, and it's up to you to make consistent visits to the property so that you make sure that the property is being well maintained. And if things start going off the rails, you act quickly to get the tenant to pay for the cost of repair and or to get rid of a tenant who simply is not utilizing your property in a positive way. You want to make sure that you are protecting your most valuable asset. To do more of that, I recommend that you watch the additional catalog of videos that we have on this channel. YouTube seems to think that this video right here is the next best thing for you. Watch it and anything else we have here. If you have a question or comment, leave those below. And until next time, landlords, happy leasing.